I want to talk to you about the anatomy of a personal injury case in Missouri or Illinois. But because we're in St. Louis County, I'm going to start with St. Louis, Missouri. If you're involved in an accident, what should you do? The very first thing you should do is make sure that you and your passengers are safe. That means that you can pull over to the side of the road, you can move your vehicle, and then call the police. You can move your vehicle even before the police arrive to protect yourself or others. If anyone is injured, call 911, get medical care. So the very first things that you should do is protect yourselves from further injury. Then get all the medical treatment that you need. Then you should call a lawyer. So you always want to get a police report to make sure that you record the events that occurred. And a police report is admissible. The police officer makes a contemporaneous report and can come in and testify as to the data that he collected. Most of the time, the police officer's opinion as to what caused the injury or the collision, like failure to yield or improper turn or excessive speed or inattention, those contributing factors do not come into evidence at trial. It's your trial lawyer's job to prove that. You don't get the police officer's opinion in unless the police officer actually saw what happened. So that is an opinion that does not come in. But you always want to get a police report to make sure that you record the events from that collision. Then after you get your care, you need to call a lawyer. And the reason you want to call a lawyer is the insurance company is just not going to treat you fairly without a lawyer. Insurance companies are in the business of collecting premiums and not paying benefits. If you think the insurance company is going to treat you fairly without the threat of a lawsuit, I'm sorry, but you're mistaken. You need a lawyer. Whether it's me or someone else, get a lawyer. You should meet with that lawyer. We only handle cases that are injury cases. We don't handle property damage only cases, and we don't handle claims that we don't believe are meritorious. If we don't believe you, we won't represent you. But if you have a real claim, come to us. We do not charge a fee unless we win. We will then send lien letters, which are letters saying, hey, we're suing you, we're claiming a lien for our services, and we intend to pursue this case. Please refer this letter to your insurance company. And a lot of people will send back or call you and say, we don't have insurance. Your case isn't over. If the defendant that hit you did not have insurance, we can make a claim against your own insurance company for what's called uninsured motorist coverage. So don't get worried. That's another thing that insurance companies will say, well, there's no coverage, and even though you're injured, you don't get treatment and you suffer because you think that there's no money to get, but that's incorrect. So get safe, get the care you need, call your lawyer, make a claim. A lot of times people call us and say, Mark, what's taken so long? Well, I don't have a crystal ball. I can't predict your injuries or what your damages are going to be until you're finished with all your treatment. So that's why we, in some cases, assist in getting medical care. I mean, we have people with herniated discs and broken arms and shoulders and legs. You need to get all the treatment you need. So we can't resolve your case. And in Missouri, we have 5 years. In Illinois, you only have a couple years. But in Missouri, you have 5 years to file your lawsuit. So we ought to get all the treatment that you need. And if you're 3 months in, I can't tell you what your case is worth because you might need a surgery to your neck or your back. So once you're done with all your treatment, then we collect every single bill and record. And we don't just collect them the way you get them with that sheet of paper from the medical providers. We get certified copies of your bills and records. That means that someone is making an attestation. They're saying, we swear that these are the true and correct records. And that's what we need to get your medical bills into evidence and to get your medical records into evidence. That does not get medical opinions into evidence. And so we're still talking about pre-suit, but we collect all those records and we send them out to the insurance company. And the insurance company might say, well, yeah, there's a back complaint there, but the person's 50 and overweight, and therefore we believe that injury is degenerative, happened with age and didn't happen from the occurrence. So even though you have all those records, and even though they say you have a back injury, and even though you had injections to your back, and even though you have a recommendation for surgery, the insurance company is trying to say, wait a minute, all those things are true, but they're not caused by the collision. So that's why a lot of times you get all this treatment and you have a disparity. We're demanding the policy limits and they're offering you a, bupkis. So then what do? We've got all your treatment, we've collected all your records, we made a demand, they made an unreasonable offer. Then, and only then, after you've had a chance to vet those issues, do you file a lawsuit. Now, by the way, you also may have lost wages. But lost wages in most states, including Missouri and Illinois, if you win those things, they're taxable. You got to pay Uncle Sam. Personal injury money is not taxable. So you're much better off to get $100,000 for your personal injury case than you are to get $10,000 for your personal injury case and $90,000 for your lost wages. Because your $90,000 in lost wages, you're going to owe taxes on. So anyway, that's another topic. But in your pre-lawsuit damages, you're looking at your injuries, your bills, your records, and your lost wages if you can prove them. You get your offer from the insurance company. Sometimes that gets it resolved. Sometimes there's a bad fact in your case. You know, hey Mark, I had an injury 3 years ago, playing softball. Well, we're pre-litigation. I don't need to disclose that. But once you file a lawsuit, then all that stuff is what's called discoverable, and they can take your deposition and send you written interrogatories. So one of the things that a good trial lawyer does is analyze all the facts. Hey, what's going to come out if I file this lawsuit? Maybe we're better off now in a pre-litigation posture. Most of the time you're not, but sometimes you are. I've had cases that I've filed, and a few months before we find out that there's, it's a shoulder injury. We find out that there's video of my guy fast pitch baseball. That's a loser of a case. That makes your case go way down, because then all of a sudden the fact that you testified that you couldn't do this and that and this is completely unbelievable. So you got to be forthright, honest with your lawyer in that pre-litigation stage and all throughout the litigation. But anyway, so you've got all your treatment done. We filed a lawsuit. Now the adjuster's out of the case. The defense has a lawyer. The lawyer may reanalyze that case, and sometimes it goes way up in value, and they say, hey, Cantor's got us. You better pay him. But if they don't, that's fine. Then we litigate, and we go through all of the discovery. That means that the suit's been filed. It's been served upon them. There's been a formal answer to our complaint, where they usually just say deny, 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 deny. They admit in part, deny in part. But anyway, so that's the answer. Then you do what's called discovery. You do written interrogatories, requests for production. We want to know if they got a video or photos of the scene. They want to come and take your deposition, which is your sworn statement under oath. And I have another video called How to Win Your Deposition. But the reason that you want a lawyer is we want to protect you from you. So we're not letting you make any statements outside of our presence about your case. No social media, no Instagram, no Twitter. We want to control the information that's out there, not because we're lying, but because why should we give them a recorded statement early in the case? They call you up, we want a recorded statement, but we're not going to tell you the policy limits. And we're not going to tell you how much insurance are there. Well, that's a no-starter for me. It's like playing poker, and they're not telling you how much they're betting. Okay, so you need to know the policy limits. There's a lot of things that can derail this. I'm just telling you globally the anatomy of a personal injury case in Missouri or Illinois. So now you're in suit, you've done your discovery, you've done your depositions. Suddenly things soften. Maybe your case got better, maybe it got worse. The other side's getting more reasonable. We have a trial date looming. We have motions to keep certain evidence in or get certain evidence out. We've taken witnesses' depositions, and every case is different. But that's the way it normally goes. And you have a pretrial conference. The judge makes certain legal rulings about what evidence can come in at trial and what can't. Then you go through voir dire, which is where you pick your jury. And in Missouri, you might start with a pool of 36 people or 50 people, and you're getting down to 12 jurors. You've got to get a majority of those votes to win in Missouri. It's not a unanimous vote. And they determine both liability and damages. Then you have your whole jury trial, your opening statements, okay? They're the way the case is going to go. You put on all your evidence, the defense gets their opening statements, and they're putting on their evidence as well, and you do your closing, and then the jury comes back with a verdict. The jury decides the amount. The judge does not decide the amount. This is not a workers' compensation case. I'm talking about the anatomy of a civil case. So I may have missed some things here because I'm just trying to give you a brief overview, but that's the way the case goes. And the reason it takes time is it's easy to settle a case and it's easy to lose a case. It's really tough to win a case and be able to put plaques on the wall, and I have them all over Cantor Injury Law. We have many millions and millions of dollars worth of both verdicts and settlements in cases that are denied. So if you have a question about a serious personal injury case, I invite you to come and speak with us for free. My name is Mark Cantor. I will meet with you. It's Cantor Injury Law. It's all I've done since 1993. 314-628-9999. Thank you for watching.